you for joining us today. My name is Yongki and I'm a senior associate at Scott Legal PC. Today's webinar will focus on how to move from a non-immigrant visa to green card in the United States. Before we dive in, let me briefly introduce our firm and go over a few housekeeping items. We are a full-service immigration law firm, and we offer representation across a wide range of practice areas, including E2, O1, TN, L1, H1B, and all types of employment-based and family-based green card cases. That said, we are particularly well known for our work in the complicated green card cases, and we have built a strong reputation throughout those comprehensive approaches and strategies. We have processed more than 1,000 cases of these complicated cases and have been able to secure approvals for the vast majority of them. At the end of this webinar, we'll send you several useful tools. A copy of a PowerPoint presentation we'll go through today, a link where you could download guidelines with more details on visa options, a link to sign up for additional webinars, a link to the webinar recording on YouTube. We encourage you to subscribe and hit the notification button as we regularly post immigration related videos. And lastly, a link where you can sign up a private consultation with our team. Finally, for any questions, please type them into chat box or Q&A box. We'll discuss all the questions at the end of presentation. And with that, let's get started. So the first thing we need to talk about is how green card system works in the United States. The US green card system is quite different from other countries. For example, in Canada, they use a point-based system, which gives points all different things like education, language ability, work experience, age, and other factors. Another example is like United Kingdom. In UK, it's not like every visa, but certain types like work visas will let you apply for the permanent residency after 5 years. United States immigration system does not work that way at all. Instead, there are several green card categories that you have to simply pick and apply for the one based on your eligibilities. So, for example, even if you live in the United States for 10 years with your TN visa or your E2 visa, it does not automatically lead to a green card. The US green card system is primarily broken into two ways. One is family-based and the other one is employment-based. Employment-based including the investment-based as well. So under the family-based, immediate relatives category is for the US citizen spouse, unmarried children, and under the age of 21, and parents if the sponsoring citizen is over 21. And the preference categories have multiple subcategories. For more detailed information, you may look at the Department of State's visa bulletin, but a couple of good examples are such as a spouse of a U.S. permanent resident or brothers and sisters of U.S. citizens. Employment-based green card categories are broken into total 5 big categories from EB1 to EB5. EB1 is generally known as extraordinary ability case. EB2 have two subcategories. One is a national interest waiver and PUM case. PUM case is where application process go through the Department of Labor first before you submit the application to USCIS. EB3 is also going through the PUM processing and based on company's sponsorship. EB4 is religion based, and finally EB5 is investor based. For these employment based categories, We'll discuss more detailed information in later slides. So next slide. What is the family-based green card? The immediate relatives are most popular way to process your foreign national spouse's green card case. The preference-based categories have a total 5 different subcategories from F1 to F4, but the two well-known examples are the ones I mentioned before: spouse of U.S. permanent resident and brothers and sisters of U.S. citizen. A big issue of these preference-based categories is that the case processing time is governed by the Department of State's visa bulletin. And the Department of State announces the visa bulletin every month, they update every month, which causes a lot of backlogs. This means while the green card case for immediate relatives are always available, the green card cases for the preference-based categories may not. So depending on which countries you are from and or which category you are applying for, there may be some significant delays before your green card case is finally processed and approved. For example, the F4 category, which is for the brothers and sisters of US citizens, needs to wait almost 17 years nowadays. That takes that much. This limited number of green card rules by the visa bulletin applies to employment-based green card categories as well. So each employment-based green card category also has annual cap of how many green card can be issued. So once a particular category has reached the annual cap, the application may experience some delays. And that's why it is important to check the monthly visa bulletin announced by Department of State when you are preparing your green card case application. Next, let's talk about the process for the family green card case. The review process is basically two parts. First part is the I-130 main petition. You need to submit that, providing that whether petitioner and beneficiary really has a bona fide relationship, which is marriage based or parent-child sibling based. And then the second part would decide whether it's going to be consular processing or adjustment status for the beneficiary in the United States. If the beneficiary is outside of the United States, then approved I-130 case will be automatically transferred to National Visa Center, where beneficiary will need to submit required civil documentation before case is eventually transferred to the U.S. Embassy in his or her home country. Okay. But if beneficiary is inside the United States, then beneficiary may apply for the adjustment of status by filing Form I-485 with the USCIS. And as part of the I-485 application package, the beneficiary may apply for the I-765 and work permit and I-31 travel authorization. Some situation requires additional processing, like third steps. For example, when marriage-based green card cases filed, USCIS will impose a condition on the green card if the marriage has not been more than 2 years. So in that case, beneficiary will need to go through the condition removal processing after 2 years. Okay. Next. So next, let's talk about EB1A, extraordinary ability green card category. This green card case is very similar to O1 visa. The particular O1A is very similar. So if you already have already successfully built up your O1A visa case, or you already got a O1A visa, then you could utilize the O1A case file, the petition package, to prepare your EB1A case. To get a successful result, you have to meet at least three eligibilities listed on the slide. Okay, basically you have to prove that you are on top of your field in multiple ways. Again, the eligibility test is very similar to the O1A visa, but please keep in mind that the level of review for the EB1A is generally higher, actually a lot higher. So for example, if your O1A was approved, but your qualification was just enough to meet the minimum requirement, that does not necessarily mean that you are ready for EB1A right away. In that situation, it may be better to wait a little longer and build up your strong track of the record. For EB1A, USCIS usually want to see stronger and more independent evidence. For example, media coverage should ideally focus on you, your own individual works, not just your company or company's achievement in the whole industry. In simple terms, O1A approval can be very positive sign, but it is not automatically green light for EB1A. So for this type of a green card route, you usually want a stronger, more mature, and more independently documented record. So next, EB2 National Interest Waiver. In short, we call NIW. EB2 has two subcategories. One is the PERM case route for the professionals with the advanced degree, and second is the other one is national interest waiver. Both of these require to meet the threshold eligibilities. You either need to have a master degrees or PhD, or a bachelor's degree with 5 years of progressive work experience. If you do not have a bachelor's degree or higher degree, then you must have exceptional ability meeting at least 3 of 7 criteria. Those 7 criteria are not written here, but you can easily look for from the USCIS website. An example to meet a threshold eligibility by exceptional ability would be, let's say for example, a famous photographer who only has a high school diploma, but he has worked as a professional photographer for more than 10 years. And because of his, reputation, he has been paid a lot more than other ordinary photographers. And his work has received recognition from major magazines, professional organizations. In that case, the photographer may be still qualified for the EB2 category under exceptional ability category. Once you meet that threshold eligibility criteria, then you need to meet the top portion of criteria in this slide. Okay. 3 things. First, an eligible case must show that the national importance of your work. It could be creating jobs, it could something that you have invented, or it could be something that provide economic benefit to the local community in the United States. Well-positioned means here in this USCIS looks at whether you are realistically capable of advancing the proposed efforts. They may consider your education, experience, skills, past achievement, track of the record, the future plan, and any progress already have made. A strong reputation or prior success can help, but the main question is whether the evidence you're presenting shows that you are the right person to move this and effort forward in the United States. Lastly, you will need to explain why government should waive the labor certification process. Please keep in mind that we are not going to discuss the EB1 and NIW eligibility criteria in very detail today. We'll only cover them in higher level because we are those 2 categories are very extensive green card categories. We have a separate webinar focus on entirely on EB1A or NIW. So if you are interested in EB1A or NIW route, I encourage you to sign up for those webinar session as well. Okay, next. So keep in mind that EB1A and NIW are both self-petition cases, meaning that you do not need a U.S. employer to sponsor you. These cases generally involve a two-step processes. First, you need to file Form I-140, which is the main petition of EB1A and NIW cases. With this, you will need to explain and prove your qualifications. The second step will depend on your situation. If you are already in the United States and an immigrant visa number is available by visa bulletin, then you may be able to file Form I-485 for the adjustment of status. In some cases, I-485 can be filed at the same time as I-140 simultaneously. If your priority date is not current, then you will need to wait until visa number becomes available before you filing I-485. If you are filing I-485, then you will also have option to file I-765 work authorization, I-131 international travel authorization as well. Another option is consular processing. So instead of filing I-485, that once I-140 main petition is approved, then you complete your immigrant visa process through the U.S. consular in your home country. You would need to attend an immigrant visa interview, and if it is approved, then you will receive an immigrant visa on your passport, not a green card. It's just visa. So the visa allow you to enter the United States as a green card status. And then once you enter the United States with the immigrant visa, then USCIS will mail you the actual green card to your home. That's what consular processing means. So next slide. The next types are when a US employer is sponsoring your green card. PUM case. By the way, PUM stands for Program Electronic Review Management. So it's a well, the wording PUM itself has been used by the immigration attorneys all the time. That's why we call it PUM, but actually it's kind of referring to the system itself. So some people call it labor certification process. Some people call it just EB3, but PUM just basically means the case that going through the Department of Labor first, and once it's approved, then you can finally file your green card case with USCIS. PUM case basically has a three-steps process. First, you need to create a detailed job description and requirement and submit the prevailing wage application to the Department of Labor. They will review it and allocate appropriate occupation title and salary amount for the proposed position. Then the company has to go through the recruitment process in the real market. Basically, they really need to run the advertisement, and U.S. job workers actually will submit their applications. If company cannot find any U.S. worker who meets the position requirement and who can perform the proposed job duties, then the application for the labor certification can be filed with the Department of Labor. Once DOL approves the labor certification application, then the rest of the procedures with the USCIS are same as the ones that we discussed in previous slides. Main petition I-140 and I-485 if visa number is available. Okay, or you can go through the consular processing. So next slide is EB5 investment-based green card case. Well, It's investment based, but somehow it's kind of categorized employment based by USCIS system. The direct investment is where you create your own business, and regional center is a passive form of investment where someone else is driving the business operations. We see many people who have their own E2 business in the United States moving to the EB5 direct investment category. Those people who are in H1B or TNB just moving into EB5 regional center categories. But it doesn't have to be that way. Just because it's kind of makes sense for the E2 business holders going to the direct investment route, and those people who are in employee status then going to the regional center because they need to maintain their job status. The required investment amount is generally either $800,000 or $1,050,000, depending on the location and type of project. If the investment is made in a targeted improvement area, which is also called TEA, or in a qualifying infrastructure project, the minimum investment amount is $800,000. Otherwise, minimum investment amount is generally more than $1 million. So TEA can be either a rural area or high unimprovement area. For high unimprovement area, the area generally must have unemployment rate of at least 150% over the national average. For EB5, there is a important difference between the investor's capital investment and the business's retained earnings. EB5 focus on qualifying capital personally invested by the investor and placed at risk, which means the money later you earned by your own business and kept in the company's account is generally treated as a retained earnings, not automatically as an EB5 investment. So difference is that let's say you made $100,000 out of your business, and let's say that's the annual revenue of your business. That revenue itself is not automatically become your EB5 investment amount. However, once you take a certain portion out of to your personally, and you pay your individual tax returns for the portions of money that you withdraw from the company bank account, then the particular portion of amount that you pay the individual tax on it, only that portion can become your future EB5 investment fund. So this is especially important for the E2 business owners considering EB5 because business revenue and company profits may not account the same way as a personal fund invested into the business. The next important factor is that your investment must create 10 full-time jobs. Okay, that's why detailed business plan is necessary to explain and show how the business will create the 10 full-time jobs in the future. The 10 full-time jobs must be filled by individuals with U.S. citizens or U.S. permanent residents. Okay, those foreign nationals with the other some types of working visas, H1B or TN, do not qualify for the 10 jobs requirement by EB5. One of the biggest challenges for EB5 investors is documenting the source of the fund. E2 cases also require source of fund evidence, but EB5 source of fund documentation is usually much more detailed and demanding. USCIS will review the lawful origin of the funds and full path of the funds, meaning how the money moved from the original source to the EB5 investment is very detailedly reviewed, and you have to provide every single details. Okay. for many investors, this becomes one of the most time-consuming part of the EB5 case because some people have very complicated fund flows. It goes, some portion goes somewhere and goes to your spouse and comes back to you. And even nowadays they use the cryptocurrency account. The funds are moving without some notable the tracking. So that's why it is hard to make a very clean path of the fund for the EB5 case. So if you're thinking about EB5 route, you have to consult with your immigration specialists like us to make sure to make a really clean source of fund and trail of funds. I-526 is the main petition for the EB5 case. You may file I-485 if you are already in the United States and visa bulletin allows, or you may process the consular processing. And after you have the conditional green card for 2 years, you will need to file I-829, which must show that you have created 10 full-time jobs. Next slide. So next, in this slide, we are going to talk about some other options for the green card categories in the United States. Diversity lottery, which usually opens around early October and closes around early November, each year. However, the exact registration period can change each year, so you should always check the official Department of State website for the current year's dates. Okay. Humanitarian-based green cards may be available in certain situations. Asylum is one example. A person who has been granted asylum may generally apply for green card after 1 year. There are also special protections for certain victims of crime or human trafficking. For example, individuals with a U or T visa may later become eligible to apply for the green card if they meet the requirement. In a case of immigration reform, government may create a new type of green card categories, but we have not seen in recent years. Next, what are some other considerations? Timing consideration is the most important thing. Please keep in mind that certain type of green card case is taking very, very long time. Like EB5, which takes about 5 years. Like EB3 pump case, also nowadays it takes more than 2 years, approximately 2 years, only to go through the Department of Labor. In glorious era, like a decade ago, there was a moment that palm application was approved within a week, but that was kind of became legend now because everything is so slow with the Department of Labor nowadays. So it is very important for you to maintain the underlying non-immigrant visa status all the time. Also, if you have a visa that does not allow you to have an immigrant intent, like a E2 or TN visa, then will be very difficult to renew your visa while green card case is pending. That's why some people process multiple green card cases simultaneously as well. So planning is the key. So you should think about which route you are going to take for your green card journey. If it is multiple, that's fine. Just talk to immigration specialists and immigrant attorneys. Make sure that you are designing the case direction within the times. Okay. Those are pretty much presentation that I prepared today. Let's see whether anybody have questions. Okay, we don't have any questions today. Thank you for joining us today. I hope today's webinar was helpful to understand some high level of each US green card categories. And if we have any further questions, you can always schedule a private consultation with us. I hope you sign up for our next webinars, and we'll see you next time. Thank you.